Okay, everybody, thank you for joining us here for our second panel today. Today's topic is revamping the PTAB. We're going to take a look at the currently pending legislation. We are also going to take a look at the pending rules packages that are, I guess, anticipated or maybe should be anticipated depending upon how you look at things. So let me introduce our panel here today. We have joining us, again, starting from the audience's left going to right, we have Tim Fink. Tim is a partner with O'Melveny. Next to Tim, we have Judge Paul Michel, who is former Chief Judge of the Federal Circuit. And then last but not least, we have Stephen McBride, who is a partner with Carmichael IP. So, gentlemen, let's begin and get your open-ended preliminary views on where it is that you think we're at and what you'd like to start with. And we can go in reverse order to start. And Steve, let's begin with you. What are your thoughts on revamping the PTAB, broadly speaking?
Well, I mean, in the context of the rules package and the PREVAIL Act, I don't know that much has been happening recently. There is a package at the OMB right now for the AMPRN. That would be the proposed rules, but we don't really know what exactly is in it. And as with the PREVAIL Act, not much has happened in the last few months, other than some testimony. But there's a lot of good ideas in both of them. I think for patent owners and for just broadly speaking, and I represent mostly patent owners. So in the ANPRM, what we could tell, there were some good things like declaratory judgment standing. We had talked about that a little bit earlier in the previous panel. The fact that it would require petitioners to have declaratory judgment standing. One of the things I liked from the ANPRN is the stipulation regarding no multiple challenges. So it's kind of like a cetera stipulation that would be filed at the time that the petition is filed, stating that in order not to avoid discretionary denial, there would be you would file a stipulation stating that you're not going to further challenge in a reexamination or an IPR when you haven't already made those challenges. So I think that's a good a good provision. There's some things in there about exempting small companies as well that I think are good proposals for patent owners. But all this is kind of in the overall rubric of how much statutory authority is there to actually do some of these things, like just cut off anybody without declaratory judgment standing. So that's something that certainly will have to be fleshed out, regardless of what is in the current rules package sitting at the OMB. PREVAIL Act, I think, is much more pro-patentee in general, and I think most of the provisions in that would be things that patent owners generally would like. A few things I liked in that, obviously, as was discussed on the previous panel, is the burden of proof changing to clear and convincing. And as was discussed earlier, I think it's not really clear how much of an impact that would have, but I think it does at least make it seem like it's a more level playing field. So maybe the optics there would be a good thing for patent owners, because a lot of the complaints they have is the low burden of proof and the success rates at the IPR, in the IPR process. So I think that is certainly one thing that would be good out of the PREVAIL Act. One of the other things I really liked about the PREVAIL Act was the idea of assigning different panels for institutions.
Well, let's hold off, and before we get too more detail, let's just get our preliminary thoughts out there, and then we'll circle back to this. So Judge, how about your preliminary thoughts on revamping the PTAB?
It's the most important issue facing the country for our economy, our global competitiveness, and even our national security. We absolutely have to get PTAB restructuring right. I said when the PTAB was first stood up and became operational in 2012 that the PTAB was the most important patent tribunal on the entire planet, and I still say the same thing today. the Unified Patent Court in Europe may give it a run for its money in terms of global enforcement, but obviously for domestic U.S. enforcement, the PTAB remains the critical actor. It's the gateway to enforcement. You can't enforce a patent in America unless you can first get through the PTAB. It's more important than the courts, and not only in terms of its control of the sequence of enforcement efforts, but in terms of actual outcomes. We've had actual cases where a final judgment in a district court upholding validity was subsequently overruled by the PTAB, and the PTAB decision is the one that stuck, not the court decision, even at the Federal Circuit level. How anomalous and crazy is that from a structural standpoint? So the issue couldn't be more important. Second perspective I'd like to focus our attention on is who is the most important audience for the patent system. The prior panel, particularly Director Iancu, talked about the public without further identifying segments of the public. Some of the other comments focused on the feelings of people using the system, and the focus seemed to implicitly be mainly on litigants and the litigators. But I want to suggest that we focus instead on who are the main people whose actions are determined by how fair they think that the PTAB process is. And the two most important groups there are the investors and the inventors. If the inventors decide to keep things secret because of the weakness of patent enforcement and the difficulty of defending issued patents, then the public loses because the sharing of technological breakthroughs is decreased or maybe even stopped altogether. And secondly, the investors drive the whole system. And by investors, I mean not only venture capitalists and other sources of external capital like private equity funds and investment banks and pension funds and so forth, but business executives. They sit astride a revenue stream because they're actually selling products, at least for the larger companies. So are they going to take the risk and invest their revenue stream, or a significant part of it, in new R&D, new commercialization, new product lines, new basic research, or not? They're going to make those decisions. I have it on very good authority directly from a huge sampling of those two classes of players, of beneficiaries of the system. They calculate the odds. They calculate what are the rewards, what are the risks, what are the time frames, and they act accordingly. And they're very cold-hearted about it. If it's better to invest in China than in the United States, they'll invest in China. And it's actually already happening because the odds have been so changed by a number of things in our system here in the U.S., but particularly the PTAB. I think it's entirely possible to do. I think the PREVAIL Act makes a start. It's not in cement because no bill that's newly introduced is in cement. I know that firsthand because before going on the Federal Circuit, I spent a total of 9 years as a staffer at the U.S. Senate. So I know exactly about how much change happens along the long journey between the introduction of a bill and the final law being enacted and becoming law after signature by the President. So now's the time for everybody to participate in the debate, the dialogue, the horse trading. No one will be totally happy. Some people want PTAB totally abolished. Some people want PTAB left alone. Some people want PTAB substantially curtailed. But whatever the viewpoints are, they all need to be on the table. And the legislation really is the only way to do this. The Federal Circuit can't fix much of any of these problems. The PTAB can, but only temporarily and haltingly. And as to the rules package, I predict little or nothing will emerge from OMB. It's a political year. They don't want to make any enemies. They're not going to let the Patent Office formally propose anything very important or very controversial. So I think that package is going nowhere fast. The courts can't help, and the PTAB can't reform itself. So by process of elimination, the only serious actor capable of making changes is the U.S. Congress. And fortunately, we have very strong leadership, particularly in the Senate, bipartisan, by Senators Coons and Tillis, who have become very knowledgeable about every aspect of the PTAB and also the parallel subject of eligibility. So all the stars are aligned and everybody should show up and participate in the process. Thanks, Gene.
Okay, great. Thanks, Judge. Tim, your preliminary thoughts on revamping the PTAB?
Yeah, I appreciate Judge Michelle's comments, and I think all of that is really well said. So I won't try to top that one. Clearly, some level of certainty is vital for the system, and I think both petitioners and patent owners could probably agree on that. So the question is, how do we do it? And I think, of course, Judge Michelle is right that there's a lot of interesting ideas in the PREVAIL Act, and I think there's stuff that's hard to disagree with in there. I think it would be shaped along the way if it does get traction in Congress. I think with respect to the rules package, I think one of the things that and of course it's still at OMB, so it's not public yet, but there are meetings about it, and it's entitled discretionary factors at PTAB is part of the title. So I think we can guess that that's probably a big part of it. Rules are sort of a step along the way between internal precedent, and director guidance, and actual legislation, which is very hard to get through anything through Congress. But rules are also not easy to implement and change. So having been part of the rules process at the Patent Office, it's not a trivial matter to get a rule through. I think the current rule package, I suspect, is going to have a lot of maybe a rule codification of a lot of existing practices at the Patent Office. So with respect to discretionary denials in particular, I think as Scott said earlier on the previous panel, I mean, there's a lot of things at the PTAB that are, it's in a steady state with respect to a number of things, and especially around the area of discretionary denials and serial petitions, parallel petitions, things like that. I think they could be implemented in a rule such that they would be harder for a director to simply de-designate. You can't de-designate a rule, you have to change a rule. And rules are subject to appeal under the APA, compliance with the rules, subject to APA appeal at the Federal Circuit. So I think it's an important step. It shouldn't be overlooked in favor of legislation that might not happen. But as Judge Michelle said, it is an election year, so I wouldn't want to be giving odds on how likely the current rule package is of getting through. So, but I think it is a step in creating certainty in the existing system, just because it puts those things the Patent Office is already doing in a little more cement, which helps with giving parties certainty. With respect to PREVAIL, it does a lot of the same things. It does a few other things, such as with respect to estoppel, that I think are interesting ideas. It addresses some of the concerns with conflicting decisions. I have a different take on how some of that could be fixed, but I do think that it's something that probably all parties would prefer to see addressed. So I'll leave it at that.
Okay,
Gene,
great.
let me just
Sure.
add a
Go ahead, Judge.
perspective about progress of the PREVAIL Act. Legislation in general is easy to block, easy to slow down, difficult to pass. That is always the basic gravitational pull. However, there is a strong consensus among the very powerful leading senators, not only Tillis and Coons, but PREVAIL, and this is very significant, has as an original co-sponsor Senator Durbin. Senator Durbin is the #2 Democrat in the Senate, and he's the chair of the full committee. So the legislative path goes from the subcommittee to the full committee to the leadership of the two parties. And the fact that Durbin is backing this, I think, is a very significant factor. And basically, there isn't a consensus on every fine point that's in PREVAIL. Some of those provisions will change, and some will be fought over quite a bit, whether they in the end change or not. But I think the chance of progress and possibly even passage is actually quite good because of the level of consensus that we now know enough how the PTAB works in reality as opposed to in theory. So we know all the ways in which the original assumptions of the Congress either prove to be true or in many respects prove to be not true. And so the situation cries out for a fix. We know exactly what the problems are. We know the general nature of all the fixes, so it's down to negotiating out the fine points.
May I ask Judge Michelle a question? Because I'm actually really, it brings up an interesting question, and I'm sure you'd have an insight into this, but how would the PREVAIL Act fare on the House side, and is there a place that is there a middle ground that they could find between the House and the Senate? Or are they aligned?
It would have been assumed in past years, including recent years, that the House counterpart subcommittee was very adverse to making significant changes. That has shifted significantly because of the presence on the subcommittee of some people who really know patent law and a shift in position on the part of Chairman Issa. So the calculus has changed in favor of progress. Exact dimensions of what the bill might look like is another matter. But I think the House side will not be a graveyard for some version of PREVAIL.
Could I also ask a question of Judge Michelle and the others? The AIA had this feeling that it went back and forth for more than a decade because it was going back and forth between different constituencies like bio and biopharma on one side and big tech on the other. You don't see that happening for the PREVAIL Act?
Well, there will be oppositional forces from numerous different angles, and it will have to be hashed out. But I think there, again, have been significant changes. In the era of the consideration and then passage in 2011 of the AIA, the big tech companies, sometimes referred to in the press as the FANG companies, had enormous power and sway in Washington politics. They could get almost anything they wanted. They could stop almost anything they wanted. Google had 6 senior staff members working in high-level posts in the administration under President Obama. Since then, a lot of people have become concerned about possible abuses by the big tech companies with regard to a range of issues, including privacy, children's access to pornography, and all kinds of detrimental things. So the shine is off the big tech companies. And if you watch the most recent hearing on PARA, there was a very interesting dynamic. I thought the big tech spokesperson, who's a very able, smart guy, David Jones, was really running into huge headwinds and struggling to make an impression. That's a complete flip of 5 years ago. So there have been a lot of changes, and they're still evolving. And I don't think that any one group anymore can kill it. I also disagree with the characterization that this is essentially just a fight between a dozen big pharma companies and a dozen big tech companies. That's a huge oversimplification, really a misdescription. There are an enormous range of very important companies of all sizes and ages, all technologies that are at neither end of that huge spectrum. They're actually critically important too, economically, inventively, and politically. And the universities are a big factor here, and they're very much involved now in a way that they weren't before. So the political dynamics, the economic dynamics have shifted quite dramatically in recent years. I think that changes all the predictions that one would have made 2 years ago versus what predictions could be soundly made today.
Okay. Okay, so with that introduction, Steve, let's go back to you where you, and before I forget, before we get too far into this, I want to make sure everybody knows for the CLE panels, we have the materials that will support the CLE are posted on the pages for each of the panels in case you want to take a look at those or you need those. One of those, and why that comes to mind presently, is one of the articles for this particular panel was written by Steve. And Steve has gone through all of the bills, and he's gone through the rules. And I didn't want to step on you because I do want to get to your line item as to what do these actually say, and we want to collectively talk about whether we like it or whether we don't like it. So why don't we go back to where I so rudely interrupted you, and I apologize.
Oh, no, I totally understand. So yeah, I mean, there's a lot of good stuff in the PREVAIL Act, and I think as Tim and Judge Michelle were commenting on, I do think that's probably the best path forward for most of this stuff, rather than the rules, is actual legislative action. Some of the stuff, the burden of proof, change to clear and convincing for preponderance of the evidence, that's one of the things that is seems like it has a fair amount of support for most of the people I've talked to, and that would be a big change. I'm not sure how much it's actually going to change the success rates, but I do think that at least optically it's a good look, because it does seem like it provides fairness to patent owners. It also looks like it integrates with the district courts, which is an important thing. I mean, I think kind of the arbitrage between the district court standard and the PTAB standard is something that can come up, and it's something that can be kind of abused in various briefings. So getting a single standard, I think, is overall a good thing. One of the neat things that I was talking about from the PREVAIL Act that it did was suggest different panels for institution and for the final written decision. And I think, again, that's an optics thing. It's probably best practice is to have two different panels to decide things, to avoid confirmation bias and to avoid any look of, potentially look like there's some sort of bias on the panel. So I think that's another good suggestion from the PREVAIL Act. And then the same with the ANPRM with the rules package. There's a lot of attention paid to ending duplicative serial and or parallel proceedings, including the declaratory judgment standing for petitioners, and that's requiring essentially declaratory judgment standing for petitioners in order to bring and have instituted an IPR. And I think a lot of those things are reflected as well in the rules package, or the ANPRM rather. It's not actually a rules package. I think a lot of those same sentiments with respect to serial and parallel, ending serial and parallel IPR petitions, as well as the declaratory judgment idea, the declaratory judgment standing idea, are also reflected in the ANPRM, although it still remains to be seen whether any of that's actually in the rules package. That's still sitting there.
Mm-hmm. So Judge Michelle, let me ask you about your favorite part of the bill particularly, and is there any part of the bill maybe that you would like to see implemented specifically, even if it had to be like cut off Or, I mean, or is there something that you would also like to see in the bill that's not in the bill?
Everything that we have now is disjointed, uncoordinated, inefficient, and frictional, the opposite of what we need. We need certainty, predictability, and incentives for inventors and investors and business leaders to want to move forward as briskly as they possibly can. So everything that integrates, everything that simplifies and removes the clashes between the courts and the patent office, particularly the PTAB, that's paramount, and that's most of the PREVAIL bill. One other thing I'd like to say about that bill is the PREVAIL Act is just the current incarnation of what was previously called the Stronger Patents Act, and before that, the Strong Patents Act. And it was actually largely written a decade ago by experts in collaboration with Senator Coons. So it's been under research and work and refinement for a whole decade already. That's as long as it took to get the AIA from start to finish. So that's a factor that really is quite significant. But we need to have it integrated and consistent. So everything should be completely uniform. And on things like estoppel, it should run in both directions. If either forum has come to a final decision, the alternative fora should be blocked, full stop.
Okay. So Tim, how about you? Your thoughts on what? Let me turn on the microphone. Your thoughts on what the bill has that you specifically like, or things that you'd like to see in it that aren't there?
Yeah, I think a good example is I mentioned estoppel earlier, and I think it's an interesting thing that the bill is attempting to move up estoppel effectively to institution, which I read as being a statutory codification of the FinTIV/Cetera stipulation with the Cetera stipulation. And that would essentially require it would take the idea of FinTIV and implement it, and then say if you agree, if estoppel happens at an institution, well, that's the thing you would stipulate away with Cetera. I think that's an interesting idea. I think it doesn't go to one of the problems currently, which is that you have concurrent proceedings that can keep going. So what I mean is, it's okay. I mean, yeah, it's great. You could stipulate away your IPR defenses in district court to prevent the district court from essentially reaching the opposite conclusion on the same arguments. But you can't stop the district court, and so so that means that the district court could end up litigating infringement under one set of claim construction and one broad view of the claims based on what the plaintiff is asserting, and then the PTAB could reach a decision of invalidity on a more constrained reading of the claims, and that's still, I think, a problem. And I think it's also inefficient to have a jury trial that's going to be upended, even if it's only on infringement, to be upended by the IPR perhaps a couple of months later for some very fast district courts. So that's something that I think the PREVAIL Act is trying to get at, but I think it doesn't fully address the problem. The problem being the concurrent proceedings. The answer to that I've seen anecdotally, and full disclosure, I represent petitioners more often, and often they're technology companies with claims such as patent claims such as you described earlier that sometimes are claiming a different color. Maybe not quite that extreme, but often it's very minor distinctions from the prior art. And being asserted against something that a technology company could not have foreseen even being asserted against them. Or so, but I've seen in many situations, and this is purely anecdotal, I'd be very happy to hear what other people think about it, where when IPRs are instituted, patent owners will agree to a stay. So if the petitioner moves for a stay pre-institution, it's almost always denied. Depending on the court, it's almost always denied. However, after institution, especially if it's a 4-patent case and 3 or 4 of the patents have IPRs instituted against them, patent owners will often just agree to a stay. I don't know whether this is being driven by litigation funders. You have a panel on that, so maybe that'll come up. But I think what it tells me is that patent owners see it as economically efficient to let the IPR play out, and even an appeal to the Federal Circuit, let it play out, and what they come back with is full estoppel against petitioner, because claims survive IPRs. Patent owners have very good counsel. There's sometimes very good dependent claims that are difficult to challenge. Claims can survive. You can appeal to the Federal Circuit. You might win, you might not, but at the end of that process, you have, I think, if you're the patent owner, you have good, strong claims that the petitioner can no longer challenge in court. So I think a stay really gets to that issue. We had that in CBMs, but the CBMs expired, of course, so we don't have that in IPRs. But to my mind, that's the best way to address the concurrent proceeding issue.
So I want to ask you a question, and I don't know whether you've given a lot of thought to it or not, but when you say you look at these patents, like I mentioned in the previous panel, I see an awful lot of very thin, very weak patents when you look across the spectrum of what the Patent Office actually issues. Do you get the sense that that's, well, why do you think that is? I mean, is it a situation where this could have been claimed better? There is really an innovation there that just is not coming through, or is it whatever it may be? Have you stopped and wondered about that? Because
sure.
Go ahead.
Yeah, no, absolutely. I think in many cases you look at and I'm not going to give specific examples for protect the innocent, but you read a patent, and I'd love to hear other thoughts on this, but you read a patent and you say, wow, there's really an invention here, or, in the specification, and that might never be claimed. Mm-hmm. And I have a couple of patents. I won't give you the numbers to protect me, but they're expired. They're expired. I was an engineer before I was a lawyer. I have to say, as an engineer, what are these claim things at the end? I didn't understand It's talking about pluralities and means fors and things like that. I read the specification and looked at the figures, and I said, wow, this is very good. This looks accurate, and I didn't really understand the claims. And this isn't something we should encourage, but I didn't have a in-house attorney telling me, pay attention to the claims, or whoever drafted it. So claims get drafted very broadly. And to me, it seemed like a foreign language until I became a patent lawyer. What the claim, and I suspect for most engineers and inventors that the claims are a bit of a mystery, the way peripheral claiming is done. And so there is a really broad independent claim, and then a bunch of narrower claims. And sometimes even the narrower claims don't capture what's in the specification. And I think that's unfortunate. That's why there's continuation practice, of course. But that's my
Gina,
take on it.
I think there's a legal problem here. I said earlier that the Federal Circuit can't help reform PTAB, but the Federal Circuit can and must help on 2 other aspects. One is to clarify claim construction law. It is a mess. It makes claim construction so elastic and so unpredictable. Of course, you're going to get different constructions in the PTAB or in the examination or in the district court or the ITC. That's the fault of the Federal Circuit. They have numerous inconsistent decisions on claim construction. They need to go in bank and reconcile those inconsistencies and provide a clear roadmap for everybody. And it just overall, we need to get back to basics. When the broadest claim goes way beyond what's in the spec, that's a violation of Section 112. That claim cannot lawfully be issued. But examiners issue them all the time because they don't really apply 112s. And efforts going back more than a decade to train them and incentivize them to apply 112 just as rigorously and thoroughly as 103 haven't been very successful. But more needs to be done on that, because that will give us what our goal is. The applicant should get what he's entitled to and not get what he's not entitled to. And that's not happening now. And part of it's the fault of youth examiners, or inadequate time, or inadequate search of prior art. But a lot of it is really rooted back in scrambled legal doctrine. It has to be clarified. Claim construction, 103 and 112 all need clarification. It should be distilled into very simple terms that examiners and judges and jurors and everybody else can apply correctly almost all the time.
Yeah, well, once upon a time, it was pretty simple and straightforward. And I wonder whether you guys have any thoughts on this, and then we'll come back to specifically what I had thought that when the PTAB started, that those people who had wanted the PTAB and wanted to make it much easier to challenge patents would rue the day, that there would be this host of great, strong patents that would rise up. People would know the importance. They would put more time and energy into it. They would be more thoughtful. They wouldn't make the mistakes some of the mistakes we were just highlighting. And I don't see that. I mean, I think I see it in little places and pieces of places. But what I see is, and maybe it's because of budgets, I talk to prosecutors, and there's still a lot of companies want to pay 1980 prices for 2024 detail that needs to be there, and those are incongruous. You can either pay 1980 prices, or you can get what the Federal Circuit wants to see in 2024. You can't get both, and I wonder if you have any thoughts as to broader as to that, or has anything surprised you about patent practice based on the patents that you are seeing, both on the petitioner side and on the patent owner side? Steve?
Well, yeah, I still do see a lot of patents that the prosecution is questionable and not strong on. So I still see those patents coming through. And I think it goes to what you're saying, Gene, is how much do you want to pay and how good of an attorney do you want to get to prosecute your patent. So I still see people that are patent owners, inventors that are shoestringing these ideas, and then they want to assert their patents when they get them a few years later. And you say to them, well, you have serious 112 issues, or you have serious, you're claiming something that's a little bit outside of what's in the specification. How are you going to show support for that? Things like that. So you still see that happen, but there are definitely companies that invest in quality patents and good lawyers to do that job. So you also see strong ones coming through as well. But I don't think that intake process where you have you're investing in good patent lawyers, you have trained your examiners. I see so many patents where the examiner's taking some sort of talking about claim construction. I just think, how in the world does this guy understand Federal Circuit claim construction? Because I barely understand it, right? And I write about it every day.
Right.
So, and there's errors there in the prosecution history. So I think there's some of that going on.
Well, I think you mentioned bootstrapping, and I have no problem with people bootstrapping. I mean, I've been an entrepreneur my whole life since when I was 12 years old and started pushing the lawnmower around the neighborhood, and then got on a bicycle to deliver newspapers, and then I was a mobile DJ during high school and college. My career has been AFAB, anything for a buck. So I get bootstrapping, I really do, and there's nothing wrong with it. Asterisk, If you're gonna sue Google or Facebook or one of the FANGs as they're called, or one of the Silicon Valley darlings or the darling unicorn, you can't bootstrap a patent.
Yeah, you're just asking for trouble if you do that.
Right. I mean, because
I don't know
that's just not gonna work. I mean, you can bootstrap a patent if what you want to do is you want to patent a game or a toy or something that Home Depot is going to sell, because they're trying to get your rights to get it on the shelves in time for Christmas or in time for the Father's Day or whatever it may be, and you may only get one season. If you get more than one season, God bless America, you know. So, but if what you're trying to do is you want to check with 8 zeros on it after the decimal point, bootstrapping your patent is a strategy for failure. Would all of you agree with that?
Yeah, you see these patents they have great ideas, and you know there's an invention in there, but they're prosecuted by the inventor or something like that, and it's really
not
tough.
only the prosecutors. There's a big default, in my opinion, without knowing it firsthand, on the part of the examiner. The examiner has so much leverage. If there are terms in the claims that are totally unclear, the examiner should force the applicant to define them and do so clearly. If there's discontinuity between the spec and the claims, the examiner has all the leverage to say, most of these claims are outside the spec, forget it. I'm going to disallow them unless you amend them down to something that's within the confines of the spec. So there's a big default here on the part of examiners not using the power they clearly have. Now, a lot of them are young. A lot of them don't have a good enough grasp of the law. And really, the ultimate reason we need the PTAB is that it's not possible, it's not affordable to have flawless examination. We would have to have 80,000 examiners, not 8,000 examiners. The fees for private companies would go through the roof, and Congress is not going to provide taxpayer money to make up the difference. So the reality here is we're stuck with 8,000 examiners, many young, significant amount of turnover, most of them not legally trained, don't understand Federal Circuit law. So it's a very adverse circumstance, and it's the duty of successive directors to do everything they can to minimize that shortfall. But in the end, the patents that are going to be inserted in court are going to get challenged at the PTAB. And all things considered, I think that's better than not having a PTAB, even though I think it got way out of hand. And the PREVAIL Act goes back to basics. Burden of proof, requirement of standing, strong presumption of validity, and then everything else flows from that. That's what we need to do.
Yeah, so I think the way, and I'm going to ask all of you guys to go through and give me your thought on how to actually fix the PTAB, you know, to make it better, fairer, stronger, faster, you know, the $6 million man kind of routine for the PTAB. My thought is that what we have to do is we have to choose a lane. Right now we have a prosecution lane that sometimes can take 5 years, sometimes 10 years. Many tens of thousands of dollars to write a good, strong patent on something that really is a high-tech innovation, and many more tens of thousands of dollars to ultimately carry that across the finish line to get it allowed. And if it's something that needs a portfolio, then you multiply that by 100x or 1,000x. You know, so there is not an insignificant cost to prosecution from the very beginning. But then at the back end, we live in a world where there's not an insignificant cost to challenge those patents that are the most valuable. So we realize that probably 90 to 98% of the patents, depending upon the estimate used, are not going to make anybody money except for the patent practitioner. But we subject all of them to the same rigor, and then if they do turn out valuable, then we subject them to extra rigor on the back end. And I just think we need to pick a lane. Either we are going to do it on the front end across the board for everybody, or maybe we should do less. I think it would be rational to do far less on the front end, and then say, why don't we let the market tell us what patents are the valuable ones, and then that's when we roll up our sleeves and we really take a look before we say, company, you need to pull out your checkbook, or you need to stop doing what you're doing. I just think we live in this unhappy medium world where the inventor, the patent owner, gets it on the front end, and then they get it on the back end. Tim.
Yeah, I I think that's really a good point. I mean, it's, the cost difference, and maybe I'll give you an example. PTAB puts out an Orange Book study from time to time. Orange Book patents are often very, very valuable patents. And if you look at the Orange Book study, you'll see, and they call it the Purple Book study too, there's a biologic component. Those patents are not often challenged at PTAB relative to litigation, like at a much lower rate than high-tech patents. And the reason why is because they were early experience was they're actually quite hard to get invalidity at PTAB on those patents. And I suspect, talking to people, it's because when you're about to spend billions of dollars to roll out a biologic or a pharmaceutical drug patent, that you're going to invest hundreds of thousands of dollars in making this patent as good as it can be, and keeping it, defining, capturing the correct subject matter, the formulas, the formulations, the molecule, all of that stuff. Not saying there isn't any abuse there either, but those patents are tough to challenge, and so they're not challenged that often. Now, on the other hand, tech, I think, I guess that's what bootstrapping. I didn't know that term before now, but I think it's probably what you're talking about. I assume what you're talking about is low-cost prosecution.
Well, sometimes it's even the inventors in those space write the application themselves and prosecute it themselves, so it's like zero cost, and that just is not a strategy.
What I feel, where I really, and this is a tough story, because at the patent office we get inventors that would tell us these horror stories. It's not where they prosecuted it themselves, but where they paid someone, $20,000 to prosecute a couple of patents, and then they lose it later on in a post-grant challenge. And they didn't get quality prosecution up front. They didn't. Whoever counseled them probably didn't make sure that they captured correct claim scope, at least independent claims, and so that's not a lot of money for a lot of companies. $100,000 on a family of patents, but for an individual inventor, that could be everything, right? And then they have to go to PTAB and defend it and spend more money to hire someone to try to defend it, and that is unsuccessful. So that's a problem, right? And I think it would be nice if there was like a pro bono for patent owners at the PTAB. There is one for ex parte appeals, by the way, but there's not one for IPRs, and it seems like that would be maybe a way to kind of alleviate some of that. But I guess to your point, if we had a registration system more like copyright, at least people wouldn't be spending their life savings on the front end in trying to get these patent instruments that might be ultimately found invalid.
Yeah, well, what about like if it were just like a novelty? Because frankly, again, going back to some of the stuff that I've seen recently, just perusing the Gazette, it doesn't seem like obviousness in a whole lot of art units gets anything more than hand waving. Anyway, I don't know what the answer is, but and we don't need to beat that to death anymore, because I really want to make sure we spend some time to get, because Tim, I know you wanted to make sure we had some actionable thoughts about whether, we don't know what's going to be in the notice, the rulemaking exactly. What should be in it, do you think?
Well, I think
if you were king, let me put it that way, not like, and then also maybe two questions. So if you were king, what would you put in it? And then two, what do you think is politically feasible to accomplish?
What I think is politically feasible. Well, I'll start. If I were king, wow. I don't think we had that in the prep call. So what I would say is politically feasible is what I said in the beginning. I think there are practices at the PTAB that are fairly well established now. Petitioners understand that I'll give you the easiest example. Petitioners understand that they file a petition, it gets denied on the merits. They're not going to get to file another petition to correct it. And petitioners don't like that, but that's that's years of precedent now have established that that's almost always the case, unless there's some really compelling reason, which hardly ever happens. So I think that there's no question that you're going to see some level of codification of serial petitioning. I think the other thing that we did when I was there was to kind of really cut down the practice of what we call parallel petitioning. People filed 6, 8, 10 petitions against one patent with just an army of prior art, which presented a operational headache for the PTAB. How are 3 judges going to evaluate 10 petitions and come at, and that can never happen in a district court, right? You're going to get a certain amount of time to present your arguments, a certain amount of pages, and just you have to make it work as best you can. So I think you're going to see a codification of that because it's something that's relatively uncontroversial at this point, and everyone sort of has learned to live with, and there's enough certainty there that it's something that I think is politically feasible.
Mm-hmm.
And then, putting that into a rule, it would be very hard to take it out of a rule, right? Once it's in a rule, you can't just turn off the rule. It's the rule that everyone, unless you do another rulemaking.
Right.
So,
Which
But,
things are tough. Judge?
The basic goal of Congress, this is crystal clear in the legislative history. A lot of fine points are not clear, but the basic goal was to create IPRs as a cheaper, faster alternative to expensive district court litigation. That's practically verbatim from the legislative history. But the system, the way it actually has been implemented, is anything but faster, cheaper alternative to expensive district court litigation. So we need to go back to establish the basic goal as a reality and not just a statement in legislative history. And to me, that requires that there only be one forum assessing validity, full stop. Take your pick. Go to district court, go to PTAB. You can't do both. You can't straddle, you can't ping pong, you can't gang up with multiples. One attack in one forum only.
What would you think about a system where the PTABs were an adjunct to the district court? I mean, because one of the real criticisms is that anybody can bring a IPR, so you wind up getting the RPXs and the unifieds and those types of folks who are really doing it on behalf of somebody, but kind of renting their shield of their collateral estoppel shield. If you had it be an adjunct to district court proceedings, and the district court were sort of farming out the decision on whether or not the claims were valid, and then you treated it somewhat like you might like in a bankruptcy court proceeding where the bankruptcy court judge makes the decision, it has to be signed off by the district court, and as long as the bankruptcy judges kind of dotted their I's and crossed their T's, it does get signed off. And then if it's not done with enough rigor, then maybe the district court sends it back or takes over and makes changes. What do you think about a system like that maybe streamlines these two processes?
Well, the problem is the two systems are incompatible. One is an executive branch administrative agency, and the other is a Article III law court. They can't mingle duties. It's just incompatible.
I hadn't thought about that, but that's fundamentally it would create even more probably constitutional problems, I suppose, if you did that. So, Steve, what would you, if you were king for a day, or if you could put something in that you'd like to see in there, whether it's already been mentioned in the 700 plus whatever were suggestions in the ANPRM, or whether there's something that was not there that you would wish somebody suggested, what would that be?
So, as Judge Michelle was saying, I think when the AAA came out, I had assumed it was going to be you try your invalidity case in either the district court or the PTAB. And that obviously isn't what happens now. It's not either or, it's both in most cases, and maybe you have a re-exam and an extra IPR in there too. So that's one thing I wish was codified somewhere in these rules or somewhere in really the legislation, that even the PREVAIL Act doesn't really totally get into, that you have one shot at the apple. I think that's important. If I was king for the day, I would probably start with the PREVAIL Act or something like that and pass it, get behind that, and then figure out what rules I have to make afterwards. Because it seems to me that this ANPRM is suggesting a lot of rules that may or may not conflict with current statutory authority or whatever Congress is going to pass. And it also seems to me that after 10 years, we know we have some problems that are best addressed by Congress in a statute. So that would be my high-level takeaway for what to do.
You know, the other thing Congress assumed and wanted was a simplified procedure that would be documentary. The PTAB judges would look at the patent and read the spec and compare the spec and the claims and look at some prior art and make a decision from the documents. But what evolved was a litigation-like process with experts on both sides, the classic dueling experts, high credentials, opposite conclusions, and the adjudicators never see them. How crazy is that? When I've done arbitrations, I've done a fair number. In every case, the light bulb for the arbitrators went off not after the sides had presented their cases, but in the final round where we called the two dueling experts together on the stand, and we had them cross-examined only, so it was very quick, hour or two, by their lawyers first and then by the arbitrators. In every case, that's when it became really clear. So to me, it's a travesty that the experts are never allowed to confront one another or be confronted by the adjudicators themselves. They're making credibility findings, whatever they call it or don't call it, in the final written decision. So if we're going to keep anything remotely like the current process, one of the reforms that I would love to see made is make that final step like a mini trial, you know, a 2-hour mini trial. And you get much more rigor if you do it that way, just the way you do in courthouses or arbitrations.
So one of the things that I've kind of noticed is when we first started this journey down the PTAB process, it seemed like people were referring to the PTAB as they're the experts. They don't need to hear from experts. They're the experts. And the thing that for many, many years when we teach new law students and new practitioners, particularly how to pass the patent bar, we always tell them, like, if you're a PhD, your technology level now is stale and getting staler by the day. You know, you're not the expert. You're going to represent the people who are in the lab who are inventing today. And it seems like when we first started this process, thought that PTAB judges were going to be the experts. And I increasingly have been hearing over the last year or so a realization that, that's not the case. These PTAB judges, they're highly educated, they're competently trained technical judges, but they're not experts. That perhaps if there are experts involved here, it is the examiners who are talking about overruling. And I wonder, I guess, what impact does that have on this PTAB moving forward? Are we going to live with this idea that the judges are experts on everything that they see, or are we coming to terms with they're not any more experts than district court judges, or are they somewhere in between? And what does that mean for why do you need expert testimony if they are experts? And it just seems like we haven't really got a theory of the case as it is. Does anybody have any thoughts on that?
I would disagree that patent judges aren't experts. But I'm joking. I was a patent judge. No, I mean the patent judges are really well educated, and they have to be technically qualified. And I was an engineer for 10 years before I was a lawyer, and I worked at and so I view myself as able to understand technology, but I think the reality is you can't.
And can I just stop you there? I didn't mean to suggest that quite that way. What I was kind of going at is, remember back before the PTAB, when these things would get litigated, it was always the expert agency.
Yes.
The district court judge would refer to the expert agency, who is the engineer, who really, or the examiner rather, who is kind of examining usually in a real small, very small niche area. And just by the numbers of cases and the numbers of PTAB judges, those folks have to be examining or reviewing on a larger swath. That's all.
That's exactly right. And I get it. Your point is well taken there. I mean, that's of course. So there's approximately 230 or so judges, and they're hearing chemical cases, biotech cases, mechanical engineering cases, electrical engineering cases, computer cases, and even within those, there's like broad spectrum. That's many art units. That covers many art units. My neighbor is a supervisory patent examiner, and they examine multiplexers day in and day out, and so they're going to know whatever the developments are in multiplexers. They're going to be on the cutting edge because that's what they look at all day.
Right.
Our multiplexer applications. So, you're never going to have that in the patent judge. And so where it comes down to is knowing the technology well enough to appreciate what the expert is telling you, and knowing whether or not the expert is telling you something credible or not, right? And I think Judge Michel makes a really good point, which is I don't think there's ever been a live expert testimony. There's been a few live witness testimonies at PTAB. I don't think there's ever been a live expert testimony. I think if it were operationally feasible to do a short, testimony on a few issues and let the panel even examine the experts and judge their credibility, I think a lot of judges would be okay with that. I think it would have to be, it'd have to be something that, could be affordable, both for the PTAB and for the parties, I think. But it would, I think using the depositions as the cross-examination as it's done now allows the judges to make a pretty good credibility determination. I mean, I personally felt like I wasn't scratching my head trying to figure out what the experts were saying and which one was more credible than the other. But I think Judge Michel makes a really good point on that.
Judge.
The bottom line is the expert, even the younger ones, are so focused on a narrow area that their expertise in the relevant technology, forget about technology in general, in the technology in issue in the case, in the IPR or the examination, is 100 times, 1,000 times stronger than the PTAB judge. So the PTAB judges are legally trained, they're very smart, they're very diligent, they work hard, they do as good a job as they can. But on sheer expertise, they don't compare to the examiner. Bottom line, we should have a strong presumption of validity based on the successful examination, and only carefully, cautiously overturn that later.
Yeah. I think that makes a lot of sense. I'm looking at the clock. We've been going for just over an hour, so I think it's probably time for us to wrap this up. Judge, I'll give you the final word. Steve, how about we start with you for your takeaway message today for the audience? If you have one thing that they're going to remember, what do you hope that is?
I hope in terms of reform for the AIA, people come together and get serious about some legislation to do it. And look at the PREVAIL Act or something like it in the next Congress in order to try to fix the problems we all know are there.
Okay, great. Thanks a lot, Steve. Tim, your final thoughts.
I think, like I said in the beginning, the PREVAIL Act has some really interesting ideas to kind of get at the issue of conflicting decisions. Personally, what I've observed and what I think is one way to get at that is a more permissive stay regime, at least something that district courts have to consider, like they did in the CBM context. I think that worked pretty well, and it only takes a year to get a final written decision. So that would be my
Okay.
wish.
Great, thanks a lot, Tim. And Judge, your final thoughts?
The Congress has to make it clear that if you don't come to the table, you won't be heard and your viewpoint won't be considered. If they do that, everybody will come to the table. And by the table, I don't just mean have another hearing or two, as they've already done on PREVAIL. I mean have an elaborate process that gets into the details and that hears everybody's viewpoint and hashes out the contending goals of all the different factions. That's been done in other contexts, and it's basically an adjunct to the hearing process. The senators in the lead appoint somebody to run what amount to negotiating sessions or mini trials, if you will, and that's what they're going to have to do here if we're really going to hammer out all the different conflicting goals and viewpoints and come to some kind of a semi-consensus. Will never be perfect, but that'll be acceptable, that'll be credible. That most people will say that looks about as fair as it can be for the interest of everybody using the system. That should be the goal, that should be the mechanism. They know how to do it, they've done it in other cases, and I hope they'll use that process here.
Great. Well, thank you all. I really appreciate your conversation today.